Hello, Desiree, can you hear me?
Okay.
Can you hear me, Desiree?
Yeah, now I could hear you.
Yeah, you had to unmute yourself.
Okay.
Hello, Elise.
Hi, everybody.
Hello, how are you?
Hello.
Nancy.
I'm good.
Nancy, can you hear us?
Nancy, are you muted?
Hi, Elise.
Hi, how are you?
Thank you.
So John, Nancy's not muted, is she?
Hello, Jim and Nancy, you there?
Yes.
Yes.
All right, now you're fine. You had to turn your microphone on, but now you're okay.
Okay, good. I'm going away.
Okay.
Oh boy, now we just, oh, there we go.
John, you don't look like Paul Gluck. I don't quite understand that.
Paul Gluck registered the software in his name when he licensed it for the village.
Oh, okay.
Did anybody hear? My brother sent me a text. He lives in Florida, that he heard something that the president is going to be closing down.
What?
He's closing down the country like they did for COVID-19 for 2 weeks. Did you hear? And I don't know if that's a rumor or if that's factual.
I didn't hear anything.
They should close him down. So John, I didn't need the meeting ID and the password and all of that. We bypassed that. Is that true?
Sometimes you seem to need it and sometimes you don't. I don't know how they set the meetings up.
I think if you're invited, once you click that link, that it automatically opens up. But if you have to do it manually yourself, then I think you need to put a password in. Because I've done that in other situations. So I don't know if that's accurate, but that's what I seem to think.
Nah. Okay.
So John, you have the ability to mute and unmute, correct?
Yes,
People.
I believe I do.
Okay.
Hello.
Hello, Jake, how are you?
Hi.
Hey, you.
Good evening, Jake.
Well,
Good.
so far so good.
Yes. Just the way we want it.
So we're not going to see anyone working out on that bicycle behind you, Jake?
No, that's mostly just me.
Okay.
Well, I don't know what we're gonna do for a half an hour.
Well, I don't either.
Yeah, I couldn't set up the meeting for 6:45. It had to be on the half hour. So,
I'm going to read my papers.
Okay.
Okay.
Papers.
Well, we could just, have everybody check in, whatever,
Sure.
and then maybe when we get to quarter of, we could call whoever has not checked in.
Jake, do we expect all the BZA members to be present?
I believe so.
I haven't heard otherwise.
Yeah. I know I spoke to Gary a couple times. So I know he's on board.
Okay.
And Mary's
And I
on
know
board.
Mary, I'm sure is. Yeah, I haven't heard from Dave, but I guess he's hanging out in the park right now.
Yeah, I haven't seen anybody.
Now, I guess the only little issue that we're gonna have is, we'll have to kind of say, okay, it's, somebody's turn. I'm not sure how good you are at muting and unmuting and,
Well, on my end, it's quite easy. I can just point.
well, you're the guy. You have
Yeah.
to be the muter and the unmuter.
I'm the host. I show up as Paul Gluck because he's the one that filed for the license on behalf of the village.
Okay. Well, if it gets a little, I mean, I've had meetings usually with my work crew, but it's, 6 people and usually kind of, you just wait your turn.
Yes,
But if it gets a little confusing, then you'll have to kind of do a mute and unmute.
sure.
I would
Yeah.
just announce that, though.
Does that mean that if we start talking and you don't want us to talk, we get muted?
Yes.
Nice. I like it.
That'll be for the audience that comes in,
Oh, yeah, they can't talk anyway, can they?
No, basically that's one of the reasons that we, clearly did not want to open up a public hearing again. I mean, we've heard it all.
Yeah, okay, I think we should just talk about the weather for a while. We are recording.
I haven't turned the recording on yet. I figured I'd wait till 7.
Yeah.
Okay, so I see it flashing, John. It's not recording? John, I see it.
Yeah, I see. Hold
It is being held virtually Zoom pursuant to Executive Order 202.1 issued by Governor Cuomo on March 12th, suspending the New York State open meetings laws to the extent necessary for local government bodies to meet and take action without permitting person-to-person meetings. The only agenda item is the King Duchin appeal. And note that the public hearing on this matter has been closed. And while the public is invited to listen, public comments on the application will not be accepted. And let me turn it over to Elise to basically go through why the applicant is here before the board, and then we'll move on to different speakers.
Okay, so I'm not going to, I'm sorry?
Dave.
Here's Dave.
Hi,
We
Dave.
just started the meeting, Dave.
So,
You didn't miss anything.
all right, so I'm the BZA attorney. I've been asked to go through just a brief review of what brought us to this point. I'm not going to go into a lot of detail, but let me just itemize where we're at. So the house at issue is a pre-existing non-conforming building on a non-conforming lot. Now, it was sold without a certificate of occupancy, but historically had been occupied seasonally. The applicants here bought the house, wanted to renovate it, and in order to obtain a building permit, they were directed that they would first have to get site plan approval from the BAR. And once they got that, the building permit itself would have to be approved by the Board of Trustees, and that was the law at the time. So in addition to
No, that's all right. He's here.
receiving a site plan approval from the BAR, Board of Architectural Review,
The loudest.
the Board of Trustees authorized the building permit, and each of those boards conditioned their granting of site plan and issuing of building permit on the seasonal use, relying at least in part on Mr. King's indication that he and Mr. Duchin only wanted to use the building seasonally. So they went through the renovation, as I'm sure you all know, obviously, and then the seasonal certificate of occupancy was issued in 2013. Now, later, around 2017, the applicants received a building permit to put heating and cooling into the building. And thereafter, I think around 2018, they asked to be issued a year-round certificate of occupancy, which was denied by the building inspector, who determined that seasonal to year-round use would in fact be a change of use, and they needed to get variances and comply with the zoning law before that CO could be issued. Now that decision was appealed to this board. And among other things, this board, of course, has broad jurisdiction to reverse or affirm such a decision by the building inspector. Now, what happened was this board issued its determination, but it neither upheld nor reversed the building inspector's decision. Instead, this board identified numerous issues with the access to the house, among other things, safety issues, etc., but ultimately decided that this board lacked jurisdiction to decide the merits of the appeal, because this board determined that the appeal was actually a collateral attack on the 2013 seasonal C of O, and therefore it was untimely. So when an appeal is untimely, it strips the agency or the board, court for that matter, from jurisdiction. The applicants then filed a lawsuit in Orange County Supreme Court on that basis that it was in fact not untimely. That was not a rational basis for the board's decision. The court decided and agreed with the applicants and remanded the matter back to this board, the BZA, to in fact go to the merits. So that's just a very brief overview of what's happened and why we're here. What I'd like to do now for the board's benefit is frame some of the legal issues that the board should be discussing and thinking about, as they go through their deliberations. So first of all, there is a narrow question before the board, which is whether seasonal to year-round occupation of a house is change of use. And when you make that decision, I advise the board that they must be guided by the Tuxedo Park zoning law, which makes no distinction. So the board may also consider whether seasonal to full-time occupancy of a non-conforming building is an enlargement of the use, and whether in the absence of variances that enlargement is prohibited. And the section that this board would consider is 100-41A of the zoning law.
Elise, can you speak up just slightly?
Sure. So now, because the board has broad discretion to consider the impact of year-round use on the community and the neighborhood, the board may, when it's making its decision and talking through these issues, revisit many of the issues that you've already put on the record, including compliance with the zoning law, access, safety, those sorts of issues, which I think you've discussed, prior to making your last decision. The other thing I believe this board should consider is a legal question of whether or not the Board of Zoning Review actually has the authority to lift a condition of site plan approval. Oddly, or I should say, it's very unusual in my experience for a zoning, for an architectural review board to actually be delegated site plan authority instead of the planning board. But in Tuxedo Park, that is what has happened. So when the BAR received an application for site plan approval before the building permit was issued, and it went through its deliberations, one of the conditions that it imposed was the seasonal use. That condition was then imposed again by the Board of Trustees when they authorized the building permit. So look, I've outlined these legal issues. There may be more things that the board is thinking about, and I would note that the board has not met and discussed any of these issues together. So now is the time to do that. If you have questions that I believe should be discussed in executive session, I will certainly let you know, and then the chairman can decide whether or not an executive session is appropriate. You know, I would also note that should this board not feel quite ready to make its decision tonight, I would caution that you schedule another meeting within a week to make a final determination. For example, if something comes up and you're just not clear about it, you really want to seek my advice on a particular issue of law, then I think, you know, that's fine, and we can go into executive session. I don't know how it would long it would last, but unless it's cleared up quite quickly and we come back in session, I would advise that if no decision is made tonight, it be made very quickly. That was.
Elise, are you going to present us with the legal memorandum, excuse me, that analyzes the legal issues?
I have.
In addition to what you've
I have provided you some thoughts.
Yes, some thought, yes, but I'm
Yes,
looking for.
so, but it's really not my decision. It's this board's decision. So.
Right, but in my experience of nearly 50 years of working with lawyers in different situations, we always have a memorandum which says either or what, you know, analyzes. We're not asking you, we're asking you to analyze in full some of these decisions, or I am.
Okay.
Legal issues.
Okay, so, you know, that's certainly up to the board if they wish to do that. Now, before the discussion begins, before, you know, the open part of the discussion between yourselves begins, I must state on the record that in around 2009, 2010, while I was an attorney with Jacobowitz and Gubitz, I and a senior partner, a guy named Jerry Lennon, represented the neighbors, the Donnellys, in a lawsuit regarding a water line. So I did disclose this to this board when I was initially engaged, which was pretty recently, and this matter came to my attention. I disclosed that to this board. And this board has indicated that, that they have confidence in my ability to fairly advise them on this matter, and I have done so. So I did want to disclose that for the record, and I have done that. And so now I turn it over to the chairman.
Okay, I think, you know, we should maybe go through some of the issues that have been brought up in the past. You know, one of the issues, obviously, and the Judge DiNaprio really did not take that issue into consideration, was the safety of accessibility in the wintertime in that location going up the 100 steps. I know that is obviously some of the concern of the neighbors, and we have documentation from the neighbors in the past. And, you know, this has always been a concern. Another matter that I think that, you know, I'm going to let Gary discuss that, is whether we have the authority to overrule both the BAR and the Board of Trustees on a condition that they put on the property. I'm not sure legally whether we can do that, and that is probably one of the reasons that we may go to executive session to discuss that. You want to bring that up, Gary, and what your thoughts are?
Yeah, first of all, I guess and I'll make some statements, and then Elise, if you can just validate some of these points. First off, what the applicants are seeking are not variances. So I think, at least in my experience, and it's not been that long on this board, and I don't know if others, is generally the BZA is being asked to get variances to existing provisions of the law, the zoning law of the Village of Tuxedo Park. But in this case, they have not sought any variances, and there are probably a number of items, possibly including some of the points that Jake has raised regarding the safety issues that might require a variance, but that has not been asked of this board. What is being asked of the board is basically to overrule the building inspector determination regarding seasonal certification of occupancy. Now, it's clear, I think, both from what you've said, Elise, and what we have looked at, that the Village of Tuxedo Park only has one type of occupancy provision in its zoning law, and that's just a regular full-time occupancy, nothing seasonal. Also, which, you know, goes to the question, if we don't have that statute, this board's responsibility, again, is to review the law and determine if it's been applied correctly, but the actual application here was by the bar and the Board of Trustees. So whether we, as a particular board in this case, has the ability to override that determination, which is a determination between them and obviously with the building inspector, I don't know whether we even have jurisdiction to do that. And so while we might be able, and I guess I would also suggest it might be worth having an executive session on this point, is to understand that while we might be able to rule on the specific request, we cannot rule on the certificate of occupancy. So that may not be our responsibility or our jurisdiction. I also have some question with regard to the issue of, you know, the enlargement of use. I mean, I'm not sure I'm clear on that point, in the sense that there was only one use that existed. It was single family home, and that's what it's continued to be used as. So I'm not sure that there is anything that exists that would give us any guidance on that. But most importantly, I think the question is, do we even have the authority to grant a certificate of occupancy, which I assume is what the end result that the plaintiff or the is asking for, that if we remove the seasonal CO, does that allow them to have automatically the other type of occupancy? And I'm not sure that we have that authority.
Okay, so to answer very directly, that the question that you asked first is, no, we're not being asked for variances. That's not the application that's before the board. The application is whether or not the building inspector, his determination that it was a change of use was correct under the zoning law. So that must be decided by this board. The next question is, you know, do you have the authority to lift a condition that's been imposed by a board of that has authority for site plan approval? And I could discuss that, but I would prefer to discuss that in executive session, because that would be a bit of advice from me to you. I will say, however, that if this board were to uphold the building inspector, for example, then it would have to be on other terms other than a change of use. For example, if you were to reverse the building inspector, we would have to discuss whether you could actually order him to issue the unrestricted use certificate. As far as the expansion of use, I would direct the board to look at section 141A. Again, that would be, in order to find that it's an enlargement of the use, the board would have to interpret that provision in such a way that it's construed to be an enlargement. Again, that's something that we could discuss, but probably we would want to discuss it in executive session.
Other comments?
Mr. Chairman, you may want to give the applicant an opportunity to speak.
iPad 149, do you have any comments you'd like to make?
iPad 149 doesn't, but Joseph Jurgen does, and I'll be brief. I do appreciate what you folks are doing. I know this is not the best of times to be doing this, sitting in your homes at 7 o'clock at night going over this stuff, and I can tell that there's been a degree of preparation which is appropriate for this application, and I do appreciate the time and effort that's being spent by everybody. I do. Obviously, I come at this from my client's perspective, and the way I see this is that an application was made to the building inspector. The building inspector issued a very specific, call it denial, but the letter is there. It's in the record for everyone to see. The reasons why it was denied are in the record. And we came here the first time asking for an override of the building inspector's determination on that very specific ground that use is use, and a single family home is a single family home. It's not a single family home in the summertime and not in the wintertime. It's a single family home is a single family home. And that's the way your code is written. When I came here the first time, I think that was pretty much what my argument was in front of you. I know that there were other concerns, and I'm not going to say they're not valid concerns. There were concerns that were expressed both by the public, and there were concerns expressed by members of the board. However, you're construed to follow the law here, and all we're asking is, was the determination of the building inspector that this is a seasonal use, and changing from a seasonal use to a full-time use, was that a change in the quote use under your code? And I mean, you've said it, several of you have said it, your attorney has said it, your code doesn't have that distinction. And I mean, to me, the easy answer here is that your code doesn't have seasonal use as a definitional as a definition. Therefore, a single family home is a single family home. Now, I did hear people raise the issue of, can you increase the use of a non-conforming use? And that's something that that's an issue that has been around for a long time. There is case law on that. Your attorney will certainly tell you what the case law is. You don't have to take my word for it. But typically, when you're talking about increasing a non-conforming use, you're talking about building on an extra, wing on something, doing something so that the intensity of it is increased, not just that you get to use it during different times of the year. It's just not the way I see it. But like I said, your attorney will for sure explain that to you. I just, when I heard counsel cite to a section for non-conforming use, I have the Village of Tuxedo Code in front of me, and just for clarification, that's all. That's all. I see non-conforming uses defined in section 100-24.2. Am I wrong?
I don't have the code in front of me, so I'm
Okay.
going to assume
Because
that
you
if
said a
you have
different,
it in front of you, that-
number.
Oh my God.
Yeah, you said a different number.
yeah.
And-
I would just, I did cite 100-41A.
Right.
And it
And
has,
I didn't,
that goes to issuance of building, issuance
okay.
of certificates. So, yeah, so
Okay,
so
then-
definitely
then-
want to look at that.
Okay, then I would ask the board to specifically look, because you do have code sections that relate specifically to
Mhm.
non-conforming uses and also to non-conforming buildings and increasing the intensity of it. And I mean, the first section, it says no non-conforming use shall be enlarged, altered, extended, or restored, or placed in a different portion of the lot or parcel, and then it goes on. Those are all physical things. And that's not what we're seeking to do here. We're not seeking to change anything physical about this. We did, or my clients did, go through a pretty extensive and expensive process to make heat get to the building so that it could be habitable in the winter months. And that was, we sought an application, we sought approval for that, and we got approval, and we did that. So that's not the alteration that we're talking about here. All we're asking is, can we walk in there, in the winter months? And I argue that is just not, it's just not increasing the intensity of the non-conforming use under the cases. And, I'm not going to comment on some of the things that were, I think, outside of the record for this particular application. I'm not saying that the concerns expressed by the chairman and others are invalid. I'm not going to pretend that they are. I'm just saying that for the purposes of this particular application, they're not relevant, in my view. So that's all I have to say. Thank you.
I would just like to thank you for those comments. Also, just want to point out something that Judge Onifrey said, which was, in any event, this is a determination for the ZBA in the first instance.
Yes.
He means the BZA.
Yeah, I saw that too.
And the ZBA should be afforded the opportunity to fully set forth and explain the reasoning and basis for a determination on the merits. So I am going to argue that to the extent that the safety issues, et cetera, were set forth in the original decision and are in the record, that this board doesn't have to repeat all of them here, but if you would feel more comfortable, we can.
No, I don't think that's necessary. I think we have a difference of opinion as to whether or not certain issues are appropriate to decide this particular application. But I'm not saying, I'm not quibbling with the fact that you've put them on the record, and I understand where they're coming from, and I get it. You don't have to repeat them again.
Right. And those issues that you believe are not appropriate to the discussion are, can you name them?
Well, there were issues that were raised regarding where you're going to park in the wintertime. There were issues that were raised about, going up steps, those kind of things. I'm not saying those aren't valid concerns. They are valid concerns. However, for this application. What I'm saying is that right now, for this specific question as to whether or not a single-family home, using it in the wintertime is a change of use as opposed to summertime, it's not relevant.
Thank you.
So to a degree, you're not arguing like Judge D'Onofrio, he listed all those points, but he basically agreed with you that the point that was made that overrode the other points was the timing of, and he remanded it back to us because of the timing, because that was not a valid excuse, basically. Correct?
Well, I think that was one of the things he said, was that we weren't late in making the application. I think that's one of the things he said. I don't know that he made his determination. The judge basically said you didn't decide the issue of is a full year as opposed to
Right.
6 month or whatever use. Is that a change in use under your code? And I agree with him. That is kind of what I think is the question that is before the board, not the specific site issues, which they're issues, and there's an appropriate form for them. I'm just saying that's not where we are at this point.
Okay.
I would just say that the board, as you know, and your first name is, I'm sorry, Mr.
Joseph.
Joseph. So Joseph, I would just say that the authority of a zoning board of appeals is pretty broad. It can do a lot, and it can make a decision. It could, in fact, uphold the building inspector for other reasons, not the one that was set forth in the first decision. And
I don't disagree with that at all.
Yeah, and I think that's what the judge was getting at. I don't know what the board is.
I'm not telling you how to decide. I mean, I am, but
I don't know what the board is going to decide. They haven't discussed it. I have a sense that they have more questions for me specifically.
I got that too.
Yeah, and I would like to have the opportunity to advise them in an executive session.
Can I just say one more thing, and then I'll be quiet. And again, please don't take this the wrong way. This has been going on for a pretty long time now. My people applied in 2018 to use this. It was before the winter of 2018. It's 2020 now. It's the middle of 2020 now, and they haven't had what I believe is the appropriate full use of their property for several years. And I'm not saying that anything here was done improperly or anything like that, but I just ask that the board remember that when it's going and doing its analysis. It's been a couple of years that this has been going on.
Have they not been able to use the property?
Not in the winter.
But
And
that's what they had always agreed
No
to
argument.
before.
No
That's
argument.
why they bought
no
it.
argument. You're right. They can't use the property
Right.
if this isn't granted.
So I'm just going to put this out. I don't expect an answer, and it's more of a curiosity on my part. There was a request from Mr. King. Actually, I can't remember who he sent it to, and it requested an expansion of the seasonal use through, I think, through October maybe, because the global warming, it was a nice letter. I don't know what ever happened there, but was that something that your clients were satisfied with? Had that been granted, that expansion? Or
Look,
you don't have to answer, you know.
no, I'll say, I will say that I do not know specifically how they feel about that at this moment. I do know that there were probably discussions aimed, and I'll call them at seeking to resolve a dispute. I'll call them that. And I have no authority, and I'm not committing to anything. But if there's some sort of compromise that could be reached here, I think that would be a good idea. But I don't know where they are on that. I think that was probably made a long time ago, and I'd have to talk to them.
I apologize if you heard my ringing there.
No, it's okay.
Okay. So, Mr. Chairman, what would you like to do at this?
Well, does, Dave or Nancy, Mary, do you have anything you want to add to this at all at this point?
I
No?
don't think so.
I'm just, I think we do need to go to the executive session because I think that, this concept of either upholding the building inspector or not because of other things needs to be discussed, right? It's something that we really haven't talked about as a board. And I sympathize with your clients, but this is a complicated issue, so.
Mm-hmm.
Yeah, the fact that it is an interesting matter, I have to say. I've not seen anything like this before. I don't know about you, Joseph, but
It's kind of unique.
yeah.
All right, if that's the case, I'd like to go to executive session, and Joseph, we'll go to executive session. We'll close the meeting after executive session. We'll hold another special meeting basically within a week or so to kind of give the determination of where we come out of it from the executive session. Is that fair
Okay, so
enough?
then I'm going to leave. That's the only way you can go to executive session. So.
Right.
Yeah, well, you'll need a motion to go into executive session.
I'd like to make a motion to go to executive session.
I'll second it.
Second the motion.
Okay, everybody who's not on the board has to leave.
I'm going to leave. Thank you very much for your time.
Thank
Okay.
you.
Are you coming back after or no? That's it.
No, we are not.
Well, we
Okay.
have to come back here's what we'll do. We have to come back into a regular session so that we can close the meeting.
Okay.
Okay.
But you don't need to stay. We'll just make a note of when that happened.
Okay.
And, the recording will be turned off and we'll let you know.
Okay. That sounds good. All right. So I'll
Okay.
clock out then. Okay. Thank you.
Uh-huh. So we went into executive session at
We
7:41.
still have,
Black,
okay,
is he still here?
Okay.
all right.
One more person looks like needs to click off.
Well, it's John. That's John.
Yeah.
Does John need to click off? No, John can't
No,
click off.
he's the host.
I'm the
so
host.
He's the host.
So I
If he
will,
clicks off,
Oh,
we're-
look.
if he clicks off, we're all gone.
I will stop the recording.